To get started. Welcome to the first event of the semester, hosted by the Bech-Loughlin First Amendment Center. Great to see such a wonderful turnout, and welcome to people who are still streaming in. I'm Professor Steve Collis. I'm a law professor here, and I'm the faculty director of the Bech-Loughlin First Amendment Center. I was actually giving a speech last night somewhere else and got up at 3 a.m. to get here about 2 minutes ago-ish. So I'm just going to introduce one thing real quick and get out of the way before I say something stupid. And I'm going to hand it off to my colleague, John Greil, who will introduce Professor McDaniel. I do want to just introduce, to let you know what this program is. So because we received a generous donation from UT Law alum Murray and Polly Bowden, we were able to launch the Bowden Fellows Program. It's a robust fellows program. We have one resident scholar here from Venezuela who was actually in exile from the Maduro regime, and I encourage you to reach out to him and get to know him if you're interested. We have 7 non-resident fellows. Professor McDaniel today is the first of those fellows. These will be both established and upcoming scholars doing research and producing scholarship on all facets of the First Amendment from every viewpoint imaginable. And our hope is to use the Bowden Fellows Program to support them in their work. So we're giving them a generous honorarium, bringing them here so they can present their work. We'll be hosting a retreat at the end of the year where they can get critiqued and critique one another. And then we also have 20 to 30 student fellows each year. Many of you are our student fellows. So welcome. We're very excited about the Bowden Fellows Program, and our hope is that it will continue to generate great research and thought leadership on all of the many troubles that spur out of the First Amendment. I'm going to hand it over to Professor Greil now to introduce Professor McDaniel, but I do just want to say on a personal note that I got off the airplane yesterday at this conference. The conference was student groups from all over the country, universities all over the country who are engaged in projects to see how we can have productive discourse, and that's a big area of research and writing for me. And the very first person I met was the RA who worked with you on this very paper from Harvard. I had no clue what her name was, but she was all excited. And I told her, well, he's presenting on it tomorrow at the University of Texas. So that was kind of a neat personal note. With that, I'll hand it over to Professor Greil.
So we are thrilled to welcome Professor Josh McDaniel from Harvard. He leads the Religious Freedom Clinic there. So I get to plug our Law and Religion Clinic, especially for the 1Ls who are just here. You should sign up and take it as a 2L and 3L. Tomorrow, we will file a brief in the Fifth Circuit to stop the city of San Antonio from destroying an ancient indigenous sacred site. Next week, our students are going to fly to New Orleans to watch oral argument in a case where we have an atheist and Hindu client who want to protest for animal rights in a public park. So Josh McDaniel is the founding director of the Religious Freedom Clinic at Harvard Law School, got his bachelor's from BYU, and his JD from UCLA, worked on the Central District of California, the Ninth Circuit, had a very successful appellate commercial litigation career when he was tapped to go to Harvard. At the clinic at Harvard, he has had tremendous success with his amicus briefing, including some of the gold standards of an amicus brief. His briefs have been quoted during oral argument to advocates. They have been relied on in majority opinions. He's represented Hindu clients, Jewish, Christian, Muslim, Sikh, and we are thrilled to have him talk today about religious freedom historically in the military and today. Thank you, Josh.
And just one more thing, for those of you who are undergraduates and fellows and new here, Professor McDaniel is going to present for about 20 minutes, and then we're going to open it up for questions. I want you to be preparing your hard-hitting questions and really go after him, or otherwise this is not nearly as fun. So be ready. Okay.
So I'm an appellate attorney by training, and so I'm used to moot courts, where the idea is that you want, if you're judging a moot court, you want to be vicious, you want to attack. So I guess that's what I signed up for. We'll see how that goes. It's really good to be with everybody here. I have not been to UT Austin since I was a 0L looking at which law school did I want to go to. And my wife and I flew out to UT Austin. We were pretty sure that we wanted to go to UT Austin Law School. And we toured, and at the last second, we decided, we kind of chickened out, and we decided, no, we're gonna we'll go to UCLA, but my wife has been kicking me ever since, saying you should have gone to UT Austin Law School. We could have ended up in Texas. It would have been great. So in a way, I'm kind of fulfilling the dream here by coming back. So I'll be talking today about religious freedom in the military. Hey, Doug. And this is if you know anything about religious freedom, I would say this is there's a puzzle when it comes to religious freedom in the military. So what is the puzzle? So the puzzle is that historically, courts have given extreme deference to military officials, even shooting down basic constitutional right claims that are brought by service members, and on the rationale that the professional officers of the military have extremely wide latitude in determining how to equip, how to train, how to control soldiers in the military. And so courts have historically taken an extremely hands-off approach to even constitutional free speech, religious freedom claims brought by service members in the military. But we have a conflict then when it comes to religious freedom, and the conflict is kind of two layers. So the first layer is that, of course, religious freedom as a general matter is a fundamental right that deserves heightened constitutional scrutiny as a general matter. And when courts engage in that strict scrutiny, they really robustly apply it, and they hold the government to account and force the government to explain its decisions and evaluate whether there's a compelling government interest in the case. We'll be talking about how the Supreme Court walked that back in the First Amendment context, but layer two is that Congress has passed the Religious Freedom Restoration Act that requires the federal government to virtually whenever it substantially burdens religious exercise, it needs to satisfy the compelling interest test. So this is essentially the strictest constitutional test that we know in constitutional law. So we have that strict test that is the highest one that we have, but we also have this extreme high deference that we traditionally give to the military officials, even when it comes to fundamental rights. So the question is, how do we think about this? How do we resolve this? And so we have this conflict between the deference to military authorities, strict scrutiny. There's this quote I really like that actually, so the big landmark Supreme Court case, we'll talk about it in a minute, is Goldman versus Weinberger. One of the military officials in the Goldman versus Weinberger case once said that when you're looking at this issue of this conflict between military authority and religious freedom, it's like an irresistible force versus an immovable object. So what do we do? How do we reconcile this? I'll also just kind of quickly note, how did I first get involved in this issue? So the Harvard Clinic, we got involved in this case in the DC circuit, Singh versus Berger. You had a group of men of the Sikh faith that wanted to enter the Marine Corps, and they applied to the Marine Corps, but the Marine Corps essentially told them, you cannot wear your turban, you cannot grow facial hair during the 13 weeks of boot camp. After the 13 weeks of boot camp, when you get deployed, wherever you go, we'll grant the accommodation, but not during the 13 weeks of boot camp. You need to be clean shaven. You can't have any kind of head covering during that period of time. So Kelsey is here. She was with us in the clinic at the time as one of our staff attorneys, and we filed an amicus brief in that case on behalf of a Muslim public interest group to basically try to shed light for the court on how this rule also affects men of the Muslim faith. If you look at the district court decision in the case, so I know there's a lot of text here, but it's really that last paragraph before the conclusion that's really the key part. It was kind of a remarkable preliminary injunction decision because it's one of the few cases that I know of where the court basically exclusively relies on the public interest factor of the preliminary injunction test to say, I'm denying a preliminary injunction in this case. So we said, essentially, the government's interest is so overriding in this case that I don't need to look at either the merits, whether they have a valid claim under the law, or whether, the other big factor is whether there's irreparable harm that's being caused in the situation. I don't need to touch either of those. I don't need to address them. Just the public interest alone resolves this. The thing that really caught my attention was that last sentence that had the exclamation mark. I usually tell my students that's a no-no. You should not put exclamation marks in your legal writings, a general matter, unless you're quoting some kind of statement from somebody else. So that's the district court decision. The DC Circuit looks at this and really wrestles with it, holds a couple of hearings. You could tell it was a really tough issue for the judges, but ultimately ended up reversing the district court's decision. You see this also in the, just another recent example is the military vaccine mandate context. You have this whole raft of district court decisions that are addressing these claims by service members on these vaccine mandate claims. And they're just absolutely all over the map. You have decisions where the judges are saying, well, we owe this really great deference, so we're going to give the deference, and so the service member loses. You have other judges that are looking at this, and they look at RFRA, the Religious Freedom Restoration Act, and they say, well, applying RFRA case law, the government hasn't met its standard in this case. And so courts are all over the map in terms of how to handle this. Okay, so I'm going to be talking shortly about my take on this in my argument, but I wanted to first start off with just a very quick crash course in free exercise law for you all. So this is my kind of very mathematical attempt to sketch out the trajectory of free exercise law since we got kicked off with the Reynolds case in 1879. We don't need to focus on a lot of this, but some of the highlights are that we had kind of a nice high point in the 1960s and 1970s with the Sherbert and Yoder cases, where the Supreme Court adopted the strict scrutiny test for free exercise claims. Things were going great. But then we have this kind of downward descent in the 1980s, where in a number of isolated contexts, the Supreme Court begins to chip away at that strict scrutiny test. And for various reasons, whether it's Native American sacred sites or the prison context or the military context, the court adopts either different standards or essentially says that you don't get to strict scrutiny or you don't win under strict scrutiny in these contexts. And all that culminates in 1990 with a watershed case called Employment Division versus Smith that many thought at the time really gutted the Sherbert strict scrutiny standard. The court there said that unless the law is really targeting religion and is not generally applicable, you don't get strict scrutiny. The plaintiff is generally going to lose those cases. And as a result of that, we're not going to cover all of the upward trend, but one of the upshots of that was that Congress responded to the Employment Division versus Smith case and passed the Religious Freedom Restoration Act. The idea was to restore religious freedom to what it had been before Smith and to shore up religious freedom protections throughout the country. So part of that trajectory. So one of these cases I had highlighted, the 1986 case, was Goldman. So we'll talk briefly about Goldman versus Weinberger. So this was a case that came up in the military context, and Simcha Goldman was an ordained rabbi, and he was in the Air Force, and he had worn a kippah for years while on base. And it didn't become a problem until he testified at a court martial, and the military leaders didn't like that he was doing that. And so they enforced a prohibition against him on his wearing of the kippah. And this case eventually makes its way to the Supreme Court, and the Supreme Court rules against him and takes a pretty hardline stance on his claim, and essentially says, we owe extreme deference to, so here's some of the language here. In the context of the present case, when evaluating whether military needs justify a particular restriction, courts are ill-equipped to determine the impact upon discipline that any particular intrusion upon military authority might have. And so essentially advocates for great judicial deference to the military officials. In that last line, judicial deference is at its apogee when legislative action under the congressional authority to raise and support armies and make rules and regulations for their governance is challenged. So we'll be coming back to this later, but the one thing to note about this is that the court is pointing to Congress's authority in this rationale, and it's saying Congress has this authority. We owe great deference to Congress when it's exercising that authority. Meanwhile, you get Justice Brennan and Justice Marshall dissenting in the case, and they look to the third branch of government, the judicial branch, and say, here he's invoking the court's protection of his First Amendment right. The court is basically abdicating its role as the principal expositor of the Constitution. We shouldn't be doing this. Long story short, there are kind of two stages of reaction to this. So the first one that's more specific is that Congress doesn't like the Goldman decision, and it takes a couple of years for the legislature to accomplish this, but eventually Congress passes a law that addresses military dress standards and essentially legislatively overrules the Goldman case, and it basically provides that as a general matter, religious dress and apparel needs to be accommodated unless it's going to interfere with the performance of military duties. The second thing that happens, of course, as I already mentioned, is 7 years after the Goldman case is decided, the Religious Freedom Restoration Act is passed. And the thing about the Religious Freedom Restoration Act is it applies to anything that the government does. It applies to all branches of the government, and that includes even the military. And so there was this question, it both popped up during the hearings, the legislative hearings that were leading up to the passage of RFRA. And of course, there's been this lingering question ever since about how are courts supposed to resolve these types of claims under RFRA, given that we have this traditional deference that's owed, but the standard is so high. So we've got this language here. The government has to show that it's in furtherance of a compelling interest. This is the least restrictive means. Okay, so this brings us back to our question, and one of the most recent things to happen on this issue is that the Supreme Court kind of very briefly touched on this by, in its shadow docket, taking review, or not taking review, but ruling on an emergency motion in one of these vaccine mandate cases, in a case called Austin versus U.S. Navy SEALs 1-26. And the issue in that motion was actually fairly narrow. The district court had ruled in favor of the service members in that case and had granted a preliminary injunction ordering the Navy to provide the accommodation to the Navy SEALs. And the court was looking at that motion to decide, do we need to narrow that preliminary injunction so that it's not going to be impinging on military decisions about deployment and its assignments, et cetera. And ultimately the court says, yes, we're going to narrow the preliminary injunction in that respect. But what I think is interesting is you have these two separate opinions that come in the case. So one is Justice Kavanaugh concurs in the judgment, and he points to Article 2 and the president's commander-in-chief authority, and basically says this resolves this case. Under Article 2, the president is the commander-in-chief, the courts are not the commander-in-chief, so courts really shouldn't be getting involved in this business of second-guessing executive decisions about service members. On the other hand, you have Justice Alito, joined by Justice Gorsuch, pointing to a different article, Article 3, saying it's squarely within the Article 3 power for courts to assess whether the government has shown that it meets RFRA standard. So who's right on this? So my basic thesis that I have in my article is that I think both of the sides in that debate between Justice Alito and Justice Kavanaugh were missing the mark. So Justice Kavanaugh focusing on Article 2, Justice Alito focusing on Article 3. I think there should be more focus on Article 1 and the fact that Congress, when it's coming in and it's passing the Religious Freedom Restoration Act and it's applying it to the military is essentially, as applied in that situation, is making rules and regulations for the military. So this comes Article 1, Section 8, Clause 14. There's the provision. And if you recall from the Goldman case, this was actually part of the rationale of the Supreme Court in the Goldman case when it ruled against the service member, was basically saying, well, we owe this really great deference to Congress when Congress acts in this type of context. So my argument would be, with RFRA, the tables were turned, and now Congress has basically shifted its approach, and it has now interposed judicial review for service member religious freedom claims, and that makes a big difference here. I won't dwell too long on the separation of powers analysis, but I think this also fits pretty neatly within Justice Jackson's Youngstown framework. If you go and read the Justice Kavanaugh opinion, he actually quotes some of Justice Jackson's opinion in the steel seizure case. But I would argue that this is a case where Congress has essentially gone from either explicitly or implicitly delegating to the executive to handle religious freedom claims, to reversing course and no longer being silent, but explicitly saying this is how the religious freedom claims of service members need to be handled. Okay, so I promised historically today. So let's talk a little bit about the history of this and what historical support there is. So going all the way back to Revolutionary War and early Republic times, I think one of my findings is that if you look at the whole history, I think it's actually a history of pretty remarkable accommodation on the part of the government of service members' claims, but the form of that accommodation changed over time. So in even before 1776, in 1775, Congress established the military chaplaincy, and General Washington, as he was leading the troops, issued a number of important general orders. So providing for worship services every Sunday, declaring special days of fasting, humiliation, and prayer, ordering that soldiers under sentence of death be attended by a chaplain of their choosing, and much more. Another kind of interesting thing was General Washington was very much against religious bigotry, and so one of the things that he really did clamp down on was he banned I think he called it the ridiculous and childish custom of burning the effigy of the Pope on Pope's Day, because he thought it was disrespectful. So did not allow that. Okay, but so chaplains, and one of the really interesting things about chaplains was this was essentially in the early days the way that religious accommodation was provided. So nowadays we think of religious accommodation as something that's individualized. It's individualized. It's a particular service member that needs a claim. You go before an adjudicator. That adjudicator is going to kind of evaluate that case as to that particular service member. But in the early days, chaplains provided a lot of the religious accommodation. And in particular, there's one there's an interesting historical episode early on where initially General Washington orders that there needs to be one chaplain for every regiment of the military. And this is significant because each regiment hails from kind of a particular community, and they tend to be homogenous in terms of their religious background. So it might be a Lutheran group, a Lutheran regiment, or a Presbyterian regiment, and each regiment gets to choose its own chaplain. And in that way, they get a chaplain of their choosing that's going to provide the worship services that they want and that will correspond to their religious beliefs. But pretty soon thereafter, Congress decides as a cost-cutting measure that it's going to do away with the regimental chaplain, and it's going to now have brigade chaplains that are going to correspond to one chaplain for maybe 6 regiments. And General Washington he was having none of it. He did not like that. He said for him it was a matter of religious accommodation. This is very important that we have one chaplain for every regiment. But the interesting thing is eventually General Washington lost that debate, and Congress imposed its will in that situation. And so you had brigade chaplains. For me, from a separation of powers perspective, I think that's interesting because it's, I think, reinforcing this idea that that whether you like the decision or not, that Congress has this primacy to regulate the troops, and that it's the one that has the plenary authority to do that. Let's fast forward, Civil War and beyond. So another interesting episode during the Civil War that also concerns chaplains is at the beginning of the Civil War, there were only Christian chaplains because as a matter of law, there was a statute on the books that provided in order to be a military chaplain, you had to be a member in good standing of some Christian denomination. So there was a Jewish campaign to overturn this. And so they went to President Lincoln, they lobbied him to change the law, and he was sympathetic to it. And he, but what he did was interesting. So he didn't issue an executive order that would say, we're going to allow Jewish chaplains, or I'm issuing an order to say we're going to appoint a Jewish chaplain. He instead ordered that a petition be sent to the relevant committee of Congress on behalf of the Israelites, and he petitioned Congress, and Congress ended up overturning that law as a result of that. And soon thereafter, we had Jacob Frankel, the first Jewish chaplain in the U.S. military, who then did really important things for the Jewish troops during the Civil War, obtaining accommodations for them, getting furloughs for them, getting liturgical items for them that they needed. So another interesting example is kind of early on, if you see on the top row there, this is Bhagat Bind Singh, who was one of the first known Sikh military officers in the armed services, who was allowed to wear a turban, but fast forward a number of decades later, no longer permitted. And so you see a number of pictures here. Some of the kind of interesting, you see a progression over time. So during the Spanish-American War, you have, in response to a request by a rabbi, the military orders that furloughs will be granted to soldiers of the Jewish faith, making application, therefore, to celebrate the high holidays. Later on, it was decided that Jewish soldiers not only be allowed to have holiday leave, but to provide, quote, facilities for partaking of such food prescribed by the religion. A few years later, the Army agreed to transport unleavened bread from San Francisco to a military base in Manila for the Passover holiday. World War I, you have Rabbi Isaac Landman that's being appointed as a detached chaplain, serving Jewish personnel throughout different regiments, helping to arrange high holiday places of worship, obtain liturgical items, transportation on Army motor vehicles. And then in one kind of really interesting episode, there's a historical account of one service where 150 Jewish service members prayed while surrounded by 500 of their non-Jewish comrades who followed along respectfully. So we see this transition over time from chaplains being the primary source of religious accommodation to the armed services affirmatively providing for religious worship and even using government funds, government resources, army trucks, things like that to facilitate the religious worship of the troops. So ultimately, I think what you see here is over time, you see these two conflicting forces over time. On the one hand, you see this increasing diversity in the military of religion, which kind of breaks down this model of having chaplains be the source of religious accommodation. At the same time, you have the conflict because over the course of the 20th century, you have the military getting more strict about dress and grooming standards, and going from a place where a turban was something that was totally permitted to no, this is not permitted under any circumstances. So again, this comes back to how should courts resolve these cases today? I want to save time for questions. So probably what I'll do is just say that my bottom line argument is that because this is Congress exercising its make rules authority, I think that changes the whole analysis in terms of how courts should think about these claims. I think they should look at it as they're not acting on their own authority. They are acting under Congress's direction under its plenary authority, and therefore they by all means should be holding government to account just as they would in any other kind of RFRA case. Does that mean that these cases are easy? No, the cases are still extraordinarily difficult. The government still has, as a general matter, very compelling interests. But one of the things that I suggest in my article is that I think the prison context is a very useful context for courts to be looking at, because if you look kind of in the background of the prison context, you see a lot of overlap between military cases and prisoner cases, where in both contexts, there were these separation of powers and federalism concerns that led courts to be very shy and very hesitant about meddling with officials' decisions. And we have a actually a very specific statute on the books in addition to RFRA called the Religious Land Use and Institutionalized Persons Act that specifically authorizes and directs courts to review prisoner religious accommodation claims under the strict scrutiny standard. And as a result of that, you actually have this wealth of lower court and Supreme Court decisions applying these cases and offering up a number of guideposts that courts can use to resolve this conflict between the extraordinarily high interest that the government has and how do we protect the fundamental right of religious freedom. So with that, I'll stop there and give you questions.
Great. Thank you, Josh. Everyone, round of applause. So the seasoned academics in the room will know that we usually do something called a queue, but we have a whole bunch of people in here that don't even know what that means. So what I'm going to do is just let you call on folks as you wish, and we wrap up. Sandra, we wrap up at 12:50. So 12:48 or something. Take the last question, maybe.
All right, yeah, green shirt.
Yeah, so could I have your thoughts on like a current situation that I've experienced in the Marine Corps? So under current uniform regulations in the Marine Corps, you are not permitted to wear a bracelet of any kind other than a memorial bracelet that commemorates a fallen soldier. But what do you say for people that are Christians that would like to wear like a rosary or something similar in nature? Whereas like that's not very distinct and it's not really going to catch anyone's eye. Whereas comparatively, like a turban is very different than the uniform norm.
Yeah, that's a really good question. I guess I'll preface this as a lawyer must by saying this is not legal advice that I'm giving, but just how would I be thinking about this? Under the Goldman case, I think that type of claim would likely lose because there was a distinction that was drawn in the military regulations at the time that the Supreme Court essentially upheld that said if it's visible, then it's not permitted. So if there's some kind of visible religious item with a few exceptions, it's not going to be permitted, and the Supreme Court approved that. Under RFRA and under the demanding test that RFRA has, I think there are likely a lot of arguments that could be made in defense of the claim there. One of the potential sticking points that a court would maybe think about is this something that the service member is saying, like, I truly am compelled. This is truly a burden on my religious belief to do this, rather than kind of a nice to have thing that I would like to do. That's usually not going to give a lot of courts very much pause thinking about that. But then you're also going to look at, I would actually be looking at the law that Congress passed in the wake of the Goldman decision, because that's actually a very specific statute on the books about religious apparel. And the standard under that is unless it interferes with the performance of military duties, it should be permitted. So you might actually have a reasonable argument under that statute. But then under RFRA itself, I would be looking at, well, what other comparable types of religious apparel or non-religious secular type of apparel are permitted? Has this been something that's been historically permitted? Is this something that's permitted by other branches of the military? You can use some of these kind of objective criteria to think about this and to essentially hold the armed services to their own rationale in terms of how you think about this. Yeah, let's go here.
So I thought your comparison with prisoners was interesting in your article, but I wonder if you recognize or acknowledge sexual asymmetry between the prisoner case and the military service members case that I might see. And I guess that's related to just like the stakes that are involved and like how that relates to the degree to which the government has a compelling interest. So like, you know, there's some policy change, and prison in some part of the country, and it leads to, you know, just unrest, and like that's a problem, but it's localized and it's manageable. Whereas, you know, ultimately, if there's some policy change in the military and we're not ready to fight a war, then, you know, the stakes are clearly a lot higher.
Yeah, I think that's an excellent point. I do think there is an asymmetry there. One of the ways I would deal with that, and this is something I didn't really get into a lot of detail because I was trying to rush through things, is I would recognize a Article 2 Commander-in-Chief authority backstop to this argument, that recognizing that there are some situations where, especially when it comes to, you know, outward facing deployment of troops, active military operations, that in those types of situations, the commander-in-chief's interest and authority to act exclusively is going to be much higher. And I think that would be very consistent with Justice Jackson's seal seizure framework to think about it in those terms. I would still argue that needs to be interpreted narrowly, and I would argue more narrowly than what Justice Kavanaugh advocated for in his opinion. But second point I would make is that I think we do need to recognize that these are enormously high stakes that the government has to deal with. And I think in most cases, the way that's going to shake out is that the court is not going to substantively question the military's interests. And if you look at the DC Circuit's opinion in the Singh versus Berger case that I mentioned earlier, you see that in the court's opinion, where the court essentially says we are not at all questioning the military's argument that this is an extremely important thing for fostering uniformity and esprit de corps. We're deferring to the government on that, but there are questions that the government needs to answer in terms of what, you know, other accommodations that it grants or other potentially inconsistent actions that it takes, or the fact that other branches of the military are able to accommodate this and it's not appearing in those contexts to frustrate the military's objectives. So it doesn't, but the government might be able to answer those questions to a court satisfaction and then win the case. So I think that's how I would think about it. Yeah, here.
It seems like the military context maybe highlights a place where asserting a compelling interest can be the to the person standard that's related to asserting a successful compelling interest might have issues because, like you mentioned just now, like uniformity could be a compelling interest. Do you see that as those things as contradictory, like that you can't force the government to assert a to the person compelling interest if they're able to say, well, the compelling interest is uniformity. So any person who's out of step with that compelling interest then, or any person who's out of step with this policy, that's a de facto compelling interest.
Yeah, so again, I'll look back at the Singh versus Berger case because uniformity was one of the big interests that the government was raising in that case. But and you actually find this a lot in religious freedom cases, is that the government will assert an interest like uniformity, but then once you start to look a little more closely at how the government is operating, you'll see that it's not operating uniformly at all. That there are myriad exceptions that it's granting, and that isn't to say that it might not be able to come up with a justification for why it has those exceptions, but I think the proper approach under RFRA would be to say, if those types of other exemptions that the government is granting are there, we want the government to come in and explain and justify, you know, why do you permit those breaches of uniformity, but you're not allowing the breach when it comes to a religious spirit accommodation. So say, for example, the military says, if you have a medical reason to grow a beard, we're going to allow the medical beard, but we're not going to allow the religious beard. In both situations, like if the stated interest is uniformity, the medical beard gets rid of the uniformity And so we then have a question of, well, why the medical beard but not the religious beard if your interest is uniformity? Let's do upper corner blue shirt.
Make sure you don't neglect this
Yeah,
after.
sorry.
Too. Yeah.
First, willingness to show deference to be attributed to the fact that now we have an all volunteer force that kind of coincides when they did start showing more deference versus historical drafting that we saw.
Yeah, I think that's that's a fair argument, but I think part of the response to that would be, once you are in that environment, it's a highly controlled, regimented environment. And essentially what it's going to come down to is if you say it's a voluntary thing, you can just choose not to go into the military. You could very easily get into a situation where the military could impose restrictions that basically categorically exclude whole religious groups because they're not able to meet the military regulations. And I think it's at least Congress's judgment, both in passing RFRA and applying it to the military. And you can also see it in that legislative response to the Goldman case that that's not something that Congress wanted. Congress did not want to be categorically prohibiting religious groups from being able to join the military, even though there is that voluntary component to it. All right, yeah, here.
This is like, how does this square with kind of adjacent issues of like conscientious objectors? Like, did that come into the paper at all, or like encountered in research?
So I think it's something to think about. I did not think so, especially because we have the voluntary forces. It's not something that I focus on too much because I'm a little bit more interested in when you are in the military, and you're in that controlled environment, what should the extent of freedom be in that situation? But one of I think historically, that is actually something that I looked at. It was interesting to see, for example, how did General Washington handle conscientious objection? And even at that point, that was something where you could find a lot of quotes where he really didn't like the Quakers' conscientious objection. He had some hot takes on that. And but at the same time, he sent letters to them saying, I think at the end of the day, your religious scruples should be respected. And there's also evidence of situations where Quakers are being forced to march with muskets tied to their backs, and General Washington reversing that and ordering that not be done. So I think my takeaway from the history of that is that there is this through line of respect for religion and religious accommodation that you can see even in that context. Yeah.
So when it comes to legislative deference, that's obviously something we want to prioritize. And what about, do you think that the standards for executive control and Article 2 power differ when it's wartime and the legislature has authorized, maybe that or designated this period as one where, that the intensity of the demands on the troops are greater than they would be?
Yeah, for me, I think that would go back to I would say there would first of all be a question of, is the Article 1 analysis different? Is there a different kind of delegation of authority, or has Congress somehow explicitly put a caveat on RFRA in a particular circumstance? Because RFRA does allow legislative caveats. The Congress, when it passes any law, can basically say this law is going to be exempted from RFRA. But then I would also say that there would seem to be a different Article 2 analysis in that situation. And so I think as a general matter, the president's maybe exclusive domain in a war context, similar to the deployment of troops context, might be greater in that case. Let's go up here.
Yeah, this may be even beyond the scope of what you looked into, but have we ever had historically a situation like we had during the Mexican War where the Irish Catholic troops refused to fire on co-religionists? In fact, more than that, they crossed over and fought for the Mexican side. After the war, they were as traitors. But we have a very diverse military force, and of course now we have forces stationed in Muslim majority countries, and we have tens of thousands of Muslim servicemen. So has there ever been a situation where maybe this would come under conscientious objector situations, but are you aware of anything?
I'm not aware. I guess my immediate reaction was that seemed analogous to a conscientious objection type situation. So that's maybe how it should be thought through. But at the same time, I would say I think in that maybe a difference in that is that when you're actually at the point of being deployed and being in active combat, I would think in that situation that the combat is so immediate that the Article 2 interests of the president in that situation would be greatly magnified in that situation because it's active, the fighting is ongoing. The further away that you get from the field of combat, I think you're going to have a lessening of that Article 2 interest of the president. Yeah, Steve.
I have a question I'm curious about because I got a call from someone in JAG the other day who has to deal with a lot of these requests. And as you know, the long history of arguing about whether or not someone should get religious exemptions, there's always this floodgates argument that comes with it, right? We saw this in Reynolds in 1890, right? Everyone will become a law unto themselves. And then Scalia invokes it again in 1990. If we allow and protect religious exercise like this, everyone will become a law unto themselves. I know there's a lot of scholars that they basically say, look, we grant these exemptions, it's going to just be anarchy because everyone will just want exemptions. And usually it seems like that doesn't always play out. And yet what this guy in the JAG was telling me is that this increasingly seems to be a problem for him. People coming in and invoking religion kind of to get whatever thing they really want. And he really questions their sincerity, but we know courts have been hesitant to do that. And I'm just wondering if, do you see that? Do you see this floodgates concern as rising to the level of a compelling enough interest that at some point the military could just say, look, we can't keep fielding these requests. We're not going to grant those, and that's it. That's the end of it.
Yeah, I guess.
What level of evidence would you need, I guess, to get to that point?
I guess I would have said I wasn't seeing a lot of evidence of that. I think maybe a different argument could be made when it comes to. I think it is fair to say that the vaccine mandate claims. It just were kind of orders of magnitude greater in number than other types of religious accommodation claims that were seen. But I think those were tough issues, and I think it's certainly an argument that the government could make that basically we're being so overwhelmed here by the sheer number. Just I guess for everybody's benefit, this is one of the tensions in religious freedom law, and in particular in terms of how do we think about the Religious Freedom Restoration Act, because the law itself says the law needs to be applied to the particular claimant. So you need to evaluate the government's interests with respect to the particular claimant. And that the Supreme Court has said, maybe beginning with a case that Professor Laycock argued in the Supreme Court, that this means that it needs to be a case-by-case analysis. But there are tricky cases out there where the Supreme Court's, especially tax cases and others, where the Supreme Court seems to take a more generalized approach. So I kind of view that as kind of a perennial puzzle of religious freedom law that I don't think is isolated necessarily to the military context or to the prison context. You see it, I think, in a number of contexts. But at the same time, I guess I would say that you see this kind of playing out. I think the government can always say, it can put on evidence and say, look, like we are receiving X number of requests. It's providing this kind of a burden. We can prove that this is actually untenable to the point that it rises to the level of compelling interest. I think the government can do that. And I just don't think that the government has really put on that kind of a case in a way that would convince a judge. So I think the system still can work and can function. But I would require the government to kind of go through the hurdles that RFRA requires before a court should agree to that type of argument. Yeah.
My follow-up would be, RFRA applies to free exercise of religion, right? What religion am I exercising when I don't want the COVID shot, but I'll take the other shot? What religion am I?
Yeah. So maybe an inconsistent one. Maybe
It's my belief. I'm calling it religion.
So I think there are different questions. So one is if somebody comes in and says, kind of as a devout Catholic, I have a religious belief. And COVID COVID falls on the bad side of that line, and other vaccines don't fall on the bad side of that line. That's a really tricky thing for courts to come in and get into that, because essentially the Supreme Court has said it's not for courts to come in and evaluate whether the religious beliefs are rational, whether they're consistent, whether there's a through line through them.
It's not religious belief, it's religion. And religion is something that can be established according to the Constitution. So it's an organized religion, I think. It's not a religious belief, doesn't say religious belief, it's a religion, exercise of religion.
Yeah, you could make that argument. I think they're gonna struggle. So usually what I see is courts looking for other doctrinal hooks to resolve cases other than that. One really quick anecdote is I actually knew somebody who this is not a military context, but he was employed with the state, had what he really wanted was a medical exemption from the COVID vaccine. And his doctor just didn't want to give him the authorization for that. So he instead asked for a religious accommodation, and he kind of brought it to me and said, "What do you think about this?" And I read it, and essentially his reason for asking for the religious accommodation was, I don't believe in the government telling me what to do, and so I should get the accommodation. And so I looked at it and I said, I don't know if a court can sanction, this is just such an overbroad thing that you could say about virtually anything that the government does. And but then the interesting thing to me was he ended up getting the answer from the state, and the state affirmatively said, we credit you having a religious belief, and it's a sincere religious belief, but we just have such a compelling interest that we're going to deny the religious accommodation to you. But to me, that was kind of an example of, even to me as a religious freedom advocate, that seemed like a pretty questionable rationale to be invoking for religious accommodation. But it might have been low hanging fruit, but still the government didn't go there, and instead found a different way to resolve the accommodation claim. So Green.
Thank you. I found your article interesting. Two questions.
Mhm.
That's okay. The first is talk about how courts should tread very carefully whenever trying to enforce RFRA in a way that his commander-in-chief powers, which his commander-in-chief powers seem to me to fall pretty easily into the category of local police now. And in that case, kind of to some other people's points, I guess I understand your argument that this would be more of the zone of twilight, but if all of the military is underneath the commander-in-chief, would it not be that RFRA has no effect actually on this because it's so. And then my second question is kind of more on the analogy of prisoners, pre-exercise cases. And I was just trying to understand, because in my head I have Alone and versus Shabazz and the other one. But the other case, those are under free exercise. And then RLUIPA is going to separately. But I know you draw the analogy too. And could you just
Sure. So maybe I'll start with the second question, and then I'll try and circle back to the first. So just for everyone's background, if you recall that chart, Alone was another one of the 1980s cases alongside the Goldman case, but it was a prisoner, a Muslim prisoner claim seeking an accommodation to attend Friday prayer services. And the Supreme Court, in a kind of an analogous type of decision to the Goldman case, essentially said, we owe great deference to the prison officials, invoked separation of powers and federalism concerns. So my argument there would be that you have kind of the same rationale that was used in the First Amendment context for courts to say we're staying out of these types of claims, both in the prisoner context and the military context. And it's already very well recognized at this point, after cases like Holt and Ramirez in the Supreme Court, that the fact that you had that Alone case as a First Amendment case, essentially that's overruled when it comes to RFRA, because RFRA and RLUIPA in particular demands the strict scrutiny standards specifically for prisoner religious freedom claims. And so courts are just not at all going to approach it the the same way. Same time doesn't mean that those cases are easy. There are still very difficult cases where the government does have very strong interests. But over time, especially in the Holt and Ramirez cases, courts have found ways to resolve those claims without having to second guess policy decisions that are made by officials, which I think is what judges should be avoiding when they confront these types of cases. On the which bucket question that you had, I would actually look at it different. Like I wouldn't look at it as Article 2 falls in one bucket or another. I think Article 2 is kind of the whole question of the three-part framework that Justice Jackson outlined is when you have this conflict between a president who's exercising Article 2 powers, and actually in the steel seizure case, the Supreme Court said that the part of the authority that the executive was invoking in that case was the commander-in-chief authority. And then how do you think about that vis-a-vis congressional authority and when there might be an overlap between the two? And so the way Justice Jackson proposes that we should look at kind of how specifically and explicitly has Congress spoken on these issues, and directionally, which way has Congress gone in terms of if it's explicit, has it basically negated, said this is something that the executive should not do, or has it given express blessing for the executive to do it? So how what bucket did this fall in beforehand? At least the Supreme Court in Goldman seemed to think that this was a bucket one type of situation where either by express or implied delegation, Congress was giving the executive officials the authority to resolve this. And so essentially in that situation, the military officials had maximum authority to do what they were going to do. Maybe there was still some work that the First Amendment could do, but it was very little work that it would do. But now that Congress has come in and expressly said, we think that these claims need to be subject to judicial review, I think that really alters that equation in terms of how we should think about it.
I think we have time for one more tight question and tight answer.
All right, we'll go here.
So with the prison military parallel, I know you also have you have state prisons and the National Guard. Do you find the state component makes things more complicated, or do you think it can already?
So I don't think it changes the analysis too much. It changes whether the term that you're using it's a federalism concern or a separation of powers concern. If anything, generally the federal government wants to take a lighter touch, and federal courts want to take a lighter touch when it comes to state officials and state level action as opposed to federal action. So you might even be able to make an argument that there's a stronger case when the federal courts are kind of minding the business of the federal government.
Okay, everyone, I'm going to ask you to applaud for Professor McDaniel.